All right, well, most of us assume that when we make a will, we get the final say over who inherits our assets when we die. But if you deliberately leave someone out and go one step further by putting a warning in your will that says if they challenge it, they'll get nothing, it's essentially what's happened in a recent case involving a Tasmanian father who left most of his estate to his sister and leaving his old Holden Calais to be shared equally by his three estranged adult children. His will reportedly included a clause warning that if any of his children challenged his wishes, they would lose what had been left to them. The case raised an interesting question for anyone who is preparing their estate. How much control do you really have over what happens to your assets after you die? And is there any way to stop someone contesting your will? I'm so glad that we're joined today by Atwood Marshall Lawyers Legal Practice Director, Jeff Garrett. Jeff, good afternoon to you.
Good afternoon, Carla.
Okay, I had no idea that this was a big misconception, that if it's, my money, my assets, my will, my final say, well, I should have final say over who inherits them if that's what I've expressed in my will. Is that not the case?
No, it isn't, Carla. And a lot of people believe that if they make a will and they record their wishes, that those wishes will be honoured or observed. But unfortunately, the law says otherwise in pretty much across Australia in relation to people's rights to contest an estate or contest a will.
Oh, well, in that case, I understand that if you were to put a clause in your will, for example, that, warned your children or whoever it was that if they challenged it, they wouldn't receive it, because a no contest clause then, it can't actually stop someone from making a claim. But if you express your wishes in your will without that part of it, surely that should be adhered to. Or can anyone make a claim?
No, no to both.
Right.
People can express their wishes, and in most cases will be upheld. However, eligible applicants are the ones who can bring a claim for provision against the estate, and that's why it's not open to anyone to do that. It is restricted to people who have the grounds to bring a claim. And that can be, there are ingredients that you need to establish for that. And one of the biggest ones for that is financial need. But getting back to the overall policy issue of, can you put these clauses in your will to stop people from doing it? It's a hard no. It's a public policy reasoning behind it. But ultimately, the body that decides whether anyone can contest the will or obtain an award from the estate rests with the court.
Gosh, okay. All right. I should say, if you've got a question that you would like to ask Jeff here from Atwood Marshall Lawyers, the Legal Practice Director, no less, the text line 0499 880 882. Of course, you can call us as well, 133 882. What about leaving someone a token amount, even if it's like $1, or in this case that we're talking about, a Holden Calais shared equally by three estranged adult children?
I don't know whether that's a gift at all, but there's one of the biggest myths is, well, if I leave someone $1 or I leave them, a peppercorn or whatever,
something nominal,
that'll be, I've made provision for that child or that relative or partner, whatever, and that's enough. Well, it isn't. All it does is it's a red flag, really, because it insults whoever you've left that dollar to. And if they do satisfy those ingredients that I was talking about, one of them being financial need, then they can still bring a claim. So, but there is truth behind that story in relation to leaving adequate provision to someone. And that's the key to avoid a claim, is to make sure that you do adequately provide for them in your will.
But what if in this instance as well, but what if you're estranged from, could be your ex-husband or your children or whatever, what if you're estranged from them and you've got clear reasons for leaving someone out of your will? Like, do you document that?
That's different. There is what they call disentitling behaviour that you can rely upon in relation to reasons for leaving someone out of your will. What constitutes the disentitling behaviour obviously varies from person to person and family to family, but it has to be pretty bad for a child who satisfies, or a claimant who satisfies all of the ingredients for a provision claim, has to be pretty bad them to be disentitled completely from bringing a claim. And, you know, it all varies. But, for instance, if someone left someone out of their will because they stopped sending them a birthday card, which has happened, that would not be a reasonable basis for cutting someone out of your will. If, however, they, there was domestic violence involved and, they were assaulted and DV orders were made and they were terrible to their parents or whatever, which has happened, that would probably be enough
be more reasonable.
Entitle them from an inheritance.
Jeff, we've just had a text in from George who says, why was that law brought in that a will can be contested?
Yeah, good question. We pretty much inherited those laws from England when our fledgling country started off here in New South Wales. So you can blame our English ancestors and the archaic legal system on that.
Wow.
It hasn't really changed since Dickensian times. So the laws in themselves, it's a double-edged sword really, because believe it or not, there are plenty of people who are unfairly left out of estates who really do need and should be provided for, but they're not. So those laws protect those people. And sometimes it's a very deserving spouse, for instance, who may have been abused over the term of the relationship. There are so many different examples of very deserving claimants, if I can put it that way, who've been left out because of someone being completely unreasonable. But the downside is that the majority of people who make their will must think about, okay, what's the prospect of someone bringing a claim against the will?
Right. And then obviously, try and challenge proof your will or, reduce the risk of a dispute later on once you passed. I guess that's why it's great we have people like yourself, Jeff. I really enjoy our chats here on the Legal Lowdown. We'll catch up with you next week. No worries, Carla. Thanks very much for allowing us to help, hopefully, the public learn more about these things. Yeah, absolutely. I had no idea that the law existed, that you could challenge a will even if it was your last will and testament. All right, Atwood Marshall Lawyers there.